Welcome to Break the Pipeline, brought to you by the law offices of Sauda Johnson PC. I am Sauda Johnson-McNeal, the founder and CEO of the firm. I've been an attorney for over 20 years, and I'm licensed in New York and California.
Hi, I'm Naomi Barerra. I am an attorney licensed in the state of New York, and like Sauda, I have also been practicing for over 20 years.
At Break the Pipeline, we dig into the real-life factors that shape children's lives. As attorneys, we analyze all sides, the legal intent and the real-life impact.
From school discipline and child labor to family conflict and mental health, we explore how laws and decisions can influence the path a child takes.
Our mission is to understand what affects kids and how we can help move them forward. This is Break the Pipeline.
Thank you so much for joining us.
Thank you. Hello, everybody, and welcome back to Break the Pipeline, hosted by the law offices of Sauda Johnson PC. I am Sauda Johnson-McNeal.
And I am Naomi Barerra.
And the title today is From Brown v. Board to the Department of Education Letter, Equality or Erasure. So we're talking about this letter. It's a Dear Colleague letter that was from February 2025. And this letter basically stated, break it down, Nate. What do they say?
So with this letter, they informed the schools throughout the nation that they cannot use race in their admissions. And they were given 2 weeks to get in compliance. Basically, get in line or you're going to lose federal funds.
What law did the Department of Education use to make this mandate? And was the interpretation proper? Let me just say the first sentence. It says, discrimination on the basis of race, color, or national origin is illegal and morally reprehensible, which I agree with.
I do too, on its face, yes.
Okay, on its face. Now, let's look at the laws. So you know, Naomi and I are attorneys, so we got to break it down. Title 6 of the Civil Rights Act of 1964. We're looking at Brown v. Board of Education, and we're looking at Fair Admissions v. Harvard, which is 2023. So, Naomi, let's start with Title 6 of the Civil Rights Act of 1964. Can you tell the people what it says and what you think it means?
Well, this law specifically prohibits discrimination on the ground of race, color, or national origin in federal funded programs. So you cannot discriminate against people that are different, that look different, or have disabilities, essentially, or you lose funds. The question is, why was that law put in place to begin with? What's the point of Brown v. Board here, Sauda?
Basically, it said that segregation is unconstitutional under the Equal Protection Clause of the 14th Amendment. And so the whole idea of separate but equal, that's basically, okay, let's talk about it. You have a bunch of kids, let's just say they're little black kids, they're in the classroom and they can be separate, but they can be equal. So their books are the same and their learning is the same, right? So everything is the same, but they're just in a different classroom. The problem with that is the books weren't the same. The little black kids had these horrible looking beat up books, as an example. They decided, no, you can't do that with race. No more separate but equal.
Brown v. Board made this law, but segregation was still taking place. So the point of Title VI was to enforce what the intent was behind Brown v. Board. You still have to desegregate. You cannot treat anyone different on the basis of race. Now,
and
things have been changed.
And Nate, let me add to that.
Yeah.
You always have to throw in federal funds, right? Because I don't know if people really know kind of the breakdown when we talk about all these federal laws, but basically the government says if you're receiving federal funding, we're talking about schools, then this applies to you. Because this is just like kind of off topic, but I want you to know that if there's a school out there that's completely like a private school, doesn't have any federal funding, any state funding, then there may be arguments that, well, you can't really touch us because we only just dealing with private money.
What was the goal with Brown v. Board and Title VI? The goal is to make equality real, not just theoretical, recognizing that there are historical disadvantages that certain people in this country have experienced. There's the theory and then there's the practice, right? The point of this law was to ensure that kids of different backgrounds had equal access to the same institutions, the same private schools, the same public schools, the same higher education, right, on the basis of you cannot discriminate. But what is this letter doing now? This letter is literally turning this on its head. But let's start with the shift. Right? What was the shift, Sauda, with the Students for Fair Admissions case in 2023?
I want to talk about affirmative action and how that comes into play here. I think affirmative action is very important as to this argument. You had Brown, and there was this progress towards integration. And then in the 60s and 70s, federal agencies and universities, they started talking about affirmative action. And that was to basically give people a seat at the table who don't normally have a seat at the table. Let's make it actual equality. People like Naomi and I, we both apply and our grades are the same. And if my name, Sauda, makes them think I'm black, maybe they won't accept me because they're like, oh, well, we're not accepting black people, right? And if you just had numbers like that continue to stack up, the next thing you know, you have a school, they don't have any black people there. The concept of affirmative action is like, no, we need to be able to allow black people entrance, and they need to be able to have a seat at the table. And it wasn't always like equal across the board. If Naomi has an A and Sauda has an A, everything being equal, then let's go ahead and see if they can both just compete based on the grades. It took into account other factors, right? Like what someone has been through historically. So that's where affirmative action came in. It basically said, we're going to give these races who do not have a chance to sit at the table or who haven't had a chance to sit at the table, we're going to give you that chance.
Using you and I as really bad examples, right? Because I'm Latina. I'm still of color. You're African American. We have to look at who is having issues with affirmative action. Who is affirmative action negatively impacting? There's been case law that people of Asian descent and white folks have been having a serious problem with affirmative action, in the sense that they're feeling like by you letting the Naomis and the Saudas into the school, the Billies and the Jakes and the Marys are not able to get in. That's what they're looking at.
You took my spot.
Right. So the question becomes, though, by removing affirmative action, is the playing field going to be leveled? What this letter is looking to undo, right? But what does that mean in actual practical terms?
So the shift is basically with the Supreme Court case that was with Harvard, and they're saying, look, you're having these race-conscious admissions. It's violating the Equal Protection Clause. If you use race in admissions, that's a violation of Title VI. You cannot discriminate based on race. It became this race-neutral directive. Everything being the same. Again, that example I mentioned, do I have an A on paper? Who is on this piece of paper for admissions? Sauda, an A. Naomi, an A. Brittany, an A. But let's say that Brittany is white folk. So now all three of these people have these A's. So if we're just looking at race neutral, then there shouldn't be a problem, right, Nate? It's just fair is fair. Everyone has an A, and it's just whoever gets in based on their academics, their, sports, community service, no problem. So what we talking about here?
But that's what the DOE is attempting to do. The problem we have in this country, let's just take it back a little bit, right? Just a little bit. The reason Brown v. Board happened was to undo the impact of slavery and Jim Crow. It was necessary so that people who didn't have access before to these higher institutions or just school in general now had access. The problem becomes, if we undo all of that behind the guise of being race neutral, if there are any administrators who don't care to give those people access, now they don't have to. They don't have to with this DOE. They can just hide behind this race neutral position, and these schools are going to start looking segregated. Let's look at Prop 209 in California. They removed affirmative action. And as I'm understanding, schools like Berkeley and UCLA, their admissions has dramatically decreased of people of color. Is that because people of color don't qualify?
So if we're really talking about colorblind reading, which is what the argument is, some people are saying, then absolutely, it only matters what's on the piece of paper, right? So if, again, using those three examples, Sauda, Naomi, and Brittany, if all of them have A's and we're not looking at race, then may the best woman win. And that's the idea of this colorblind concept. And that's what people are saying. They're like, it's only fair that you do not look at race for any purpose when it comes to admission, because anything else is going to violate Title VI. If you look at race, then what happens is somebody who may not have that A, they may have an A minus, but because they're black, well, they're going to get Brittany's spot, whereas Brittany has that A. Is that fair? That's the other side of the argument. It's like, no, it's not fair. If I have an A and you have an A minus, I don't care if you're black. That's not my issue. My issue is I have an A, you have an A minus. I should be able to get my spot into the school. So that's that one side of the coin, Naomi.
I hear you, Sauda. But they're essentially undoing the intention of Title VI. They're undoing reason and the intention behind you cannot discriminate. That's the law, but they're flipping the intent of that law on its head. It was meant to ensure that people had access. Now, if you're doing it strictly on grades, you have to incorporate that background, right? Are they equally suited in terms of their household, their financial standing, their access to tutoring and access to extra help? Are they on the level playing field, or is the kid of color, is there the fact that they come from a single parent household, that they have had to struggle? That A minus looks very different when you put all of that into place, and you have this kid who hasn't experienced any real quote unquote hardship. So you have to incorporate these backgrounds. It's only right, and that was the intent of Title VI.
It's basically regression, right? So if you don't look at race, we have all of these people who no one looks like you or I, because, well, maybe our grades weren't just as high. Maybe we did have that A minus because of what we've gone through historically. Or if I lost someone based on being killed because of my father because he was black, they killed him. Well, that's going to impact me. And that may have been the reason I got that A minus. I'm just saying, there's that. The other part of it is they can do something as just looking at my name, Sauda, and they can decide not to allow me to get into the school because of my name. What does that look like? Well, what it looks like is now they don't have to track it. They don't have to say, well, we have 100 white students here and no black students or no Latinas, and we don't have to track those numbers because this is not about race. We're not looking at that. So then there's this regression that happens by you now looking at this whole race neutral philosophy. You're in fact creating the very thing that we were seeking to erase. So that's really the dilemma if you think about it, Naomi. Am I right?
Yeah, that's it. But let's take it a step further, Sauda. What does this mean on a grander scale, right? So now you have these race neutral rules. Students that are not given access now, for whatever reason, they can't get in, be it because of their name, because they got an A minus as opposed to everyone having an A. Where does that student now go? They go to a school that is probably of less caliber, which means that they end up in a job that potentially pays them less, which means economically that student and the family that they create is now also going to be impacted long-term financially. So there's a class impact here as well.
There is, but is that, I mean, if you think about it, then is that Brittany's problem? Brittany's like, I got the A. That's what her view is. I got the A. I deserve to be here. I deserve to go to this high caliber school. Your A minus didn't get you in the school. Your A minus got you a lesser job. That's not my issue. I worked hard to get my A. You worked hard to only get an A minus. And I personally think it's unfair if I'm Brittany with the A, you're Naomi with the A minus, and you get my spot just because you're Latina. It's not fair. It's just not fair. And the other part of that too, Naomi, is there's some black people out there who say, now, you know, again, here we look at all sides, right? We're not taking a position, but there's some black folks out there that says, I don't need that. I'm super smart. I'm highly intelligent. I didn't go through that in my family. I haven't dealt with any racism. I'm good. You go ahead and put me on this piece of paper and I'm going to line up just like everybody else. I'm going to have all A's, and Brittany with her A and me with my A, I'm still going to get in because my essay is better. Or I ran track faster and she didn't run track. There's a whole bunch of black and Latinas and other people who are considered minorities who have that position. So we cannot assume that just because somebody is black or Latina or, you know, a minority, that they automatically disagree with this letter, right?
Wait. Let's say that student that you described is perfect across the board on paper, but his name is Saquon or her name is Shanisha. Now, the school can literally not know anything about that student, take literally just the name and disregard the perfection that you just described on the basis of name. And no one can say that they use race to exclude that student. That is the flip side here. And by removing these requirements, these protections that we have in place now, They can do that unfettered. And the schools are going to be different and society is going to be different. And again, what are we doing here in this society, right? Because we have to look at the bigger picture. What is the impact that's ultimately going to happen to our society? You can't say, I don't care, I got an A. Because ultimately, what happens to that other family impacts the society as a whole.
I hear you, Nate. We're always just going to have someone on this side and someone on that side. So what I always like to do is circle back when we do these podcasts or talk about where's that middle ground, right? In our previous podcast, we say, okay, we're looking at both sides. We hear both sides. Whether Naomi and I agree with it is not the point. We've basically given you both sides of the argument, what the law says and why it makes sense to someone versus the other. But now, is there a middle ground? Is there a way so that it's not unfair to the people who did get that A and not that A minus, and if they should have a spot because they just had better grades, and then simultaneously it not exclude people who look like you or I? That's really, to me, the core question. Is there a way to balance it so that it's not unfair to any side? I mean, what are your thoughts, Naomi?
I mean, I think if you have an administrator who is conscientious and thoughtful and all-inclusive, it can work. Because then they will look at the grades and they won't exclude based on just Shaniqua's name or... So it depends on who's at the helm. So there is a middle ground. Nothing we're talking about here is set in stone either way. It really depends on who is making those decisions. But we hope that those that are making the decisions are being mindful and balanced.
Yeah. I mean, at the end of the day, look at us at the firm. We've had to hire people. And even if we don't know what their race is on a piece of paper, you're going to find out the race if you end up interviewing them, right? But what we do is we look at the actual resume. We look at whether or not they are qualified before they can even get the interview. That is not looking at race. We're just saying, does this person qualify? So when we look at it in the school setting, there still has to be that standard. If we're talking about a Harvard or where I went, University of Southern California or Brooklyn Law School, there's a standard because these are top level schools. And if you're completely saying we're not going to look at race, then there has to be some type of standard. So maybe, and I'm just throwing it out there, coming out with ideas, maybe it's like, look, for our school, if you have less than an A minus, maybe you're not even eligible to be part of this conversation, regardless of race. Maybe that's one part of it. But then the other part becomes, now if someone has an A minus or an A plus or an A, now we can start looking at, okay, well, what's their personal statement like? Who is this person? What are they talking about? Have they done things in the community to help other people? Are they actively involved in sports? What's their personal story? What have they been through? What has their family been through? You know, maybe that can level the playing field a little bit. This person has to have this spot because they are Black, or this person can't have this spot because they're not Black. Maybe there's a way to somehow put some standards in place where even to be part of the conversation, you have to have certain grades. And let's not assume because we're Black or Latino, we won't have those grades. At the end of the day, part of this story in this conversation was there were Black people, there were Latinos back in the day who had these same exact grades, if not better, and still weren't being allowed into these spaces.
I think with everything else that's happening in this country, we'll find out. We're going to find out ultimately what the impacts are going to be. It seems that, again, with everything else in the law, as you know, there's the intent and there's the actual impact. So we will see what the impact of this letter will be. I'm prayerful that it'll be, like you said, that it'll be a positive one. And I'm prayerful that whoever's at the helm is going to use a conscientious approach to admissions.
You have to look at what the impact is and what the intent is. There just isn't any separation. This is Break the Pipeline, and I'm loving having these conversations with you, man.
I'm loving talking to you too, Sauda. Until next time, thank you everyone for listening.
Thank you.
Our goal with this podcast is to show two opposing views of our society, and it's not necessarily our own opinions, but we do hope that our listeners can understand that there are serious issues and not everyone is on the same page all the time. And our hope is to bring it to the community at large.
So if you want real talk, compassion, and legal insight from attorneys who care deeply about our youth, you are in the right place. We're the law offices of Sauda Johnson PC, and this is Break the Pipeline.